Today is 222 Friday group meeting. The topic is part 3 today, new criminal laws. The speaker is our beloved senior and the topmost criminal lawyer in this country and continuously is taking our lecture, Justice Nagamuthu, senior advocate. Before that, today part 1 already uploaded in our YouTube channel. We have as on date 31,000 subscribers we have in our channel. 172 videos, it's available in our one place in our channel. More than 15 lakhs viewers we have. Biggest achievement, sir, biggest achievement. If you added another 2 within another 48 hours, it will go, now you can initiate, sir, please,
Good afternoon to all of our friends. Yesterday, we covered section 164 of the old code and the corresponding provision in the new code. We will begin from there. You all know that section 164 of the old code, which empowers a magistrate to record a statement of a witness or confession of an accused, is done only during the course of investigation and not after inquiry has started or after trial has commenced. This is what yesterday I told by referring to the appropriate provision. Now, after that, the investigation goes on. So far as I already told you that so far as section 161 of the old code and the corresponding new code are one and the same, there is no change made. Regarding 162 also, there is no change made, the corresponding provision is exactly the same. Then all the other provisions in respect of the investigation are simply repeated. And finally, filing a final report under section 173 of the old code is also simply repeated and there is no substantive change made in the corresponding provision, namely section 193 of this BNSS. Now, one significant change which has been made in this provision is that some report, interview report is required to be filed to the court by the police. That is dealt with in subsection 3 of section 193, which is equivalent, which is traceable to section 173 of the old code. Here it says that the police officer shall, within a period of 90 days, inform the progress of the investigation by any means, including through electronic communication to the informant or the victim. So the victim was all along kept in dark. What is the progress made? Where are the people arrested? What are the evidence collected so far? Would never be made known to the informant at all or the victim. Now, this is a welcome change made in the law, which says that after 90 days of the registration of the case, it is mandatory for a police officer to inform the victim that this is the progress which we have made so far. This is to inform to him. So, that is dealt with in section 193, subsection 3. I will read the provision. The police officer shall, within a period of 90 days, inform the progress of the investigation by any means, including through electronic communication, to the informant or the victim. This is one change made. Now, when the final report is filed under this provision, that is under section 193 to the court, the same procedure which we had under section 173 used to be followed. There is no substantive change made at all in this. One significant change made is in respect of the power to do further investigation. You all know that under section 173(8) of the old code, though there was no need, as per the evidence, as per the CRPC, that permission used to be obtained from the magistrate. Over a period of time, the court, this honorable court, has held that though there is no such permission required, still to maintain a kind of discipline, it is desirable that the police officer has to inform the court that he is doing further investigation. It is only an information. That is dealt with in Ramlal Narang, 1979 2 SCC, page 322. See, I will read the relevant portion of the judgment in paragraph 20. We think that in the interest of independence of the magistracy and the judiciary, in the interest of the purity of the administration of criminal justice, and in the interest of the committee of the various agencies and institutions interested in the different stages of such administration, it would ordinarily be desirable, please underline this word, desirable, that the police should inform the court and seek formal permission to make further investigation when fresh facts come to light. So this is the law laid down 1979. The old code came into being in 1973 or 74, and after this was the law made. So therefore the legal position was that though the CRPC does not contemplate that permission used to be obtained from the court to whom the charge sheet has been laid, still, as per this judgment, the police officer has to take a formal permission from the magistrate or the court to which final report has already been filed. The one thing. Now, what is the other law under the old code in respect of further investigation? When the further investigation is done, you have to file a supplementary report, correct, to the very same court. The court would have already taken cognizance of the offences. In the supplementary report, if any new offence is brought on record, then the court will take cognizance of that offence also. And if only new accused are added, there is no question of taking further cognizance, the reason being that under section 190 of the code, what was then required of was to take cognizance of the offence and not the offender. Therefore, in the supplementary report, if any new offence is brought on record, for example, already there is offence under section 409, for which cognizance has already been taken. Now, the supplementary report says that there is an offence under section 420 also, that in respect of this 420, cognizance is to be again taken. So there are two cognizances taken now in a case. One cognizance in respect of offence under section 409. Now the present cognizance is in respect of offence under section 420 IPC. So therefore, there on the supplementary report, cognizance is again taken of the offence, not the offender. This you have to keep in mind. Now this is the second position which was in vogue under the old code. That position is now continued. Third position was, who has got the power or right to approach the court under section 173(8), seeking permission to do further investigation. We were all along holding that it is only for the police officer concerned, that is the investigating officer, to make an application under section 173(8), seeking formal permission. Such right is not available for anybody else, including the complainant or the accused. Now, for the first time, in Binubai's case, that was held by Honorable Justice Nariman, it was said that such a right is not only confined to the police officer, the right is extended to the victim, the informant, and also to the accused. This was 2019 position. For the first time this position was cleared by the Supreme Court by laying down law. 2019 17 ACC page 1 paragraph 42 I think. So this is the position. Now anybody can make application. Anybody means the victim, accused, informant or the police officer can make an application. This is the third position which we have been following from 2019. Now what are the changes? One more position, last position is in Venubai, Justice Nariman says that power to do investigation under section 173H cannot be extended if once trial has commenced. If once trial has commenced, there is no right for the police or anybody to ask for further investigation. Then what is the course? The only course available for the parties is to invoke section 319. They have to wait till 319 stage to collect further evidence during trial and to add any more accused under section 319. There is no question of doing further investigation. The benchmark is the date on which charges are framed. If charges are framed today, trial commences today, and therefore after today, no application seeking permission under section 173(8) could be made. This was the law on various aspects which we have been following under section 173(8) of the code. Now, Binu Bhai, which restricts the power only up to the stage of framing of charges, has been nullified by this act. That judgment no more holds the field. Now, very specifically, in section 193, they have said that further investigation can be done any time before judgment is delivered, including during trial. I will read the relevant provision. This is 193 proviso, provided that further investigation during trial please kindly see, provided that further investigation during the trial may be conducted with the permission of the court trying the case, and the same shall be completed within a period of 90 days, which may be extended with the permission of the court. So what was the law laid down by Binu Bhai saying that no, you don't have power under 173(8) to do further investigation after commencement of trial has been now done away with, and as per the new BNSS, further investigation is permissible even during trial. This is yet another welcome change which has been made in the court. One more thing, in respect of the further investigation under the old code, I said that supplementary report is to be filed. The old code reads like this: he shall forward to the magistrate a further report or reports regarding such evidence in the form prescribed. So, in respect of supplementary charge sheet, the state government would prescribe a form under which, and according to that form, supplementary report could be filed. But now, rule is to be made. Please kindly see the provision. This subsection 9 of section 193. Nothing in this section shall be deemed to preclude further investigation. Repetition of the old code. In respect of our offence, after report under subsection 3 has been forwarded, that is after filing of the final report to the magistrate, and whereupon such investigation, the officer in charge of the police station obtains further evidence, oral or documentary, he shall forward to the magistrate a further report or reports regarding such evidence in the form as the state government may by rules provide. Now, rule is yet to be issued by any state government on this aspect. So, it is necessary for the state government to issue rule as to how they find the additional evidences collected during further investigation ought to be submitted to the court. This is yet to be done. So, there is a marked difference. Under the old code, It was said that it can be prescribed by means of a mere circular or executive order. But here statutory rule is to be made as to how final report is to be filed. Therefore, for our practical purpose, let us understand only one thing, very mainly. Ramlal Naran holds a field even under this code also. Therefore, you have to seek formal permission. 1. Application seeking further investigation can be made by the accused, victim, etc. That law also holds a field even today under this act also. 2. 3. Further investigation cannot be done beyond the date of framing of charges has been done away with. Therefore, that law is not a good law today because of this specific statutory provision which empowers or which gives a right to ask for further investigation even during trial. This much is enough so far as this provision is concerned. Now, after filing of the charge sheet, what should be done by the court? Regarding taking cognizance, under section 190 of the old code, there is no change made at all. And similarly, under section 176, 1 capital A of the old code, the procedure for investigation by a jurisdictional magistrate in respect of custodial death is now repeated. There is no change made at all. The law laid down, you know very well, 2014 PUCL case. What is it? 2014 10 SCC 635, paragraph 27 onwards, which says, referring to section 176 capital A, as to how a magistrate has to hold investigation, which is in addition to the investigation done by the police, in respect of any death, custodial torture, custodial rape, etc. I will read the old provision and also the new provision. Old provision 176 1 capital A, where any person dies or disappeared, or rape is alleged to have been committed on any woman, while such person or woman is in the custody of the police or any other custody authorized by the magistrate, that is jail custody also, or the court under this code, in addition to the inquiry or investigation held by the police, an inquiry shall be held by the judicial magistrate or the metropolitan magistrate, as the case may be, within whose local jurisdiction the offence has been committed. So how this inquiry is to be held? If the inquiry is not held properly, what are the remedies available for the family of the victim are all dealt with in PUCL case. I do not want to read the judgment, please kindly go through that. Now, after this provision has been simply repeated in section 198, and there is no change made. So that judgment PUCL is even today holding the field under the new code also. Now let us go to the old section 190 under which a cognizance is taken. Now if once final report is filed, then the court has got three options. Option number 1 is to accept the report. Option number 2 is to order for further investigation. Option number 3 is, though the report is negative, the magistrate may take cognizance. These are all the old positions. There is no change made so far as this old section 190. Now present section 210, not even a single word has been changed. Therefore, in the matter of taking cognizance and order for further investigation without accepting the report of the police, the judgments of this court governing the field would continue to govern. This is under section 190. Then let us come to that 197, prosecution of public servants in respect of any offence committed in the course of discharge of his official function. Now there is only one change made, though they have not changed anything substantially, only one thing. They added one proviso. 197 says, old code, no court shall take cognizance of any offence in the of these offences etc. enumerated therein, if committed by a public servant in charge of the official duty, except with the prior sanction of the appointing authority. Now, there is a complete ban on the court to take cognizance if there is no sanction as against the public servant. Now, what was happening was, the police officer or a complainant will make a request to the authority concerned seeking permission, seeking sanction. They won't give, they will keep the papers under the table. They won't do anything. So ultimately, the court cannot take cognizance, the court cannot proceed further. The real culprit will escape. In order to avoid that, now they have added this proviso to section 218, that is equivalent to section 197, which says, provided further that such government shall take a decision within a period of 120 days from the date of receipt of request for sanction, and in case it fails to do so, the sanction shall be deemed to have been accorded by such government. So now, if no sanction is given within a period of 120 days, it shall be deemed that sanction was given, and this is the only change made so far as the old section 197 is concerned. Now let us come to the private complaint procedure. Under section 200, when private complaint is filed under the old code, the court will take cognizance of the offences on the complaint as per section 191 capital 1A of the old code. Now under the old code, until the accused is summoned, the accused has got no right of audience at all. See what happened in between? A private complaint is filed, court records the statement of the complainant under 200, takes cognizance of the offence, orders for further investigation if need be under section 202, or the court records the statements of evidence of all the witnesses and decides whether to issue summons or to dismiss the complaint. If the court finds that there is no material to summon anybody, the court will dismiss the complaint under 203, and if the court finds no there are offences and which are to be tried and these are the accused, then the court will issue summons under section 204 CRP. This was the old code. Now, as interpreting these provisions, this honorable court held in a number of cases that the accused has got no right of audience unless and until he is summoned under section 204. Until then he has got no right of audience. You may kindly refer to this Adalat Prasad, a judgment by 3 judges, 2004 7 SCC 338 page 14, paragraph 14. But after, I will read the provision. But after taking cognizance of the complaint and examining the complainant and the witnesses, if he is satisfied that there is sufficient ground to proceed with the complaint, he can issue process by way of summons under section 204. Therefore, what is necessary or a condition precedent for issuing process under section 204 is the satisfaction of the magistrate either by examination of the complainant and the witnesses or by the inquiry contemplated under section 202 that there is sufficient ground for proceeding with the complaint, hence issue of process under section 204 of the code. Please follow this. In none of these stages, the code has provided for hearing the summoned accused for obvious reasons, because this is only a preliminary stage, and the stage of hearing of the accused would only arise at a subsequent stage provided for in the later provisions of this code. So therefore, unless he is summoned under section 204, The accused has got no right of audience. When the complaint is made, the behind is back. The court takes cognizance, behind is back. The court examines the complaint under section 204, behind is back. It examines the witnesses also, behind is back. And makes a limited adjudication as to whether to issue summons or not. That is done under section 204. It issues summons. Until then, the accused has got no say at all. Now, therefore, what was happening was, there were lot of false complaints being made. After the accused appears, he comes before the court. He says there is a false case, but there are no materials to issue summons. What is the remedy available for him? In 1992, in K. Matthews case, this honorable court held that though there is no provision to discharge the accused, it is no matter. The court, on being satisfied on hearing submissions of the accused, may drop further proceedings. This was the language used in K. Matthews case 1992. Drop the further proceedings. This law was doubted in Adalat Prasad. In Adalat Prasad, by a 3-judge bench, this honorable court held that if once summons is issued under 204, the court with the issued summons cannot recall that, cannot drop the proceedings. Then what is the remedy for the accused? The remedy for the accused is to challenge the summoning order before the High Court under 482. This what was held. This was the law. Now, a complete change has been made with the new court. Now, what is said is, subsection 1 of section 223, which is corresponding to the old section 200. I will read that. A magistrate having jurisdiction while taking cognizance of an offence on complaint shall examine upon oath the complainant and the witnesses present, if any, and the substance of such examination shall be reduced to writing and shall be signed by the complainant and the witnesses and also by the magistrate. This is repetition of the old code. Now, what is new? This is by way of proviso. Provided that no cognizance of an offence shall be taken by the magistrate without giving the accused an opportunity of being heard. Please kindly note this provision. So hereafter, no cognizance can be taken on a private complaint without issuing notice to the accused. Now, the problem here is, and I will come to that later. Suppose the accused happens to be a public servant and the offence is said to have been committed in discharge of his official duty. A private complaint is to be filed. We have already said that sanction is required under section 197 already. Now, when such a complaint is made, as per this provision 223, two more safeguards are given to him. Number 1, a magistrate shall not take cognizance on a complaint against a public servant for any offence alleged to have been committed in course of discharge of his official functions or duties unless a such public servant is given an opportunity to make assertions as to the situation that led to the incident so alleged. Number 2, a report containing facts and circumstances of the incident from the officer superior to such public servant is received. So these two changes have been made. Number 1 is that if a private complaint is made against anybody, now it is mandatory that the court shall not take cognizance without issuing notice to the accused, which means notice will go to the accused will be heard, and he may produce any document, etc. Only thereafter, if the court is satisfied that matter requires cognizance to be taken, then only cognizance can be taken. in respect of a public servant in discharge of his official duties, there are two safeguards. Number one, he should be afforded an opportunity to make his assertions. Number two, a report should be called for from his immediate official superior. Only thereafter cognizance can be taken. Now, there will be some practical problem in this, that's what I perceive. We have been all along holding very consistently that what is taken cognizance of is not the offender but of the offence. So at the time when the cognizance is taken, the offender need not be known. For example, there is a theft in my house. I go and make a private complaint to the court. Now, as per the old code, the court will take cognizance because there is offence of theft committed. Court will take cognizance of that offence. Then, how the theft was committed, by whom, it is to be known. For that purpose, the court will order for investigation under 202. The police officer will not register. 202 investigation is different from investigation under chapter 12. Here they won't register any case. They will investigate and submit a report to the court. Now they will say, yes, theft has happened. So and so is the accused. These are all the property which we have recovered, and he is guilty of the offence. He will submit a report. Based on that, the court will now issue summons to the accused under 204. Now my purpose is over. I made a complaint. Cognizance is taken of the offence. Investigation goes on. Real culprit is found out. Now he is summoned under section 204. Very smoothly this was going around this country. Now, you please look at this. In the similar case where I go with a complaint that there is a theft in my house, I do not know the accused. Then to whom the court will issue notice now? Section says that you have to issue notice only after hearing the accused, proposed accused. You have to take cognizance. Now how is it possible for the court now to find out as to who was the culprit, who is the thief, so to issue notice to him? Practically it will be difficult. Therefore, in order to overcome this difficulty, what the court has to do, what the magistrate has to do is, instead of taking cognizance, instead of issuing notice to anybody, can simply refer the matter to the police for investigation as per the old code under section 153 and as per the corresponding new provision which we have already dealt with. This is the only way out. Otherwise, court cannot take cognizance. One more problem. In a given case, as against the public servants, there are number of accused. Now you say that before taking cognizance, you have to hear all those public servants. In one case where we appear here, Honorable Justice Karpana is leading us, 215 public servants involved. 215. Now, in respect of each person, you have to issue notice number 1. 215 people are to be heard. Fortunately, this case was under the old code, not under the new code. So suppose it happens now. So for all the 215 people, notice should go. When it will be served, when cognizance will be taken, I do not know. See, the purpose of the new code is to speed up the trial, the proceedings of the court. Will it really speed up? Number 1. So for all the persons, you have to issue notice, number 1. You have to hear everyone. 2. You have to get a report from the immediate superior of each person. Suppose the immediate superior also happens to be an accused in the very same case, from whom then the report is to be called for. Now, in respect of all the 215 people, if immediate superior has to give a report, how much time would it take? So these are all practical difficulties. I say that this provision, that is in respect of public servant calling for report and issue notice, I don't think that this will serve any desirable purpose. So this is in respect of private complaints. Then let us come to the supply of copies of the documents to the accused. We had under the old code 207 in respect of police report cases, 208 in respect of the private complaint cases. Now the corresponding provision to section 207 is section 230. One welcome change has been made. It says, in any case where the proceeding has been instituted on a police report, the magistrate shall, without delay and in no case beyond 14 days from the date of production of or appearance of the accused, furnish to the accused and furnish to the accused copy. So this is a welcome one. So some practice was in vogue saying that unless all the accused appear, we won't give copy. Some magistrates were doing like that. That is totally wrong. I have received summons, I come to you, in response to the summons, you have to follow the next stage, that is 207. So far as I am concerned, supply copy to me. Why should you wait for someone else? Why should I wait for someone else to appear? Though he may be the co-accused. But this was not uniformly followed. Therefore, they have made a welcome change in this. They say that from the date of first appearance within 14 days, you have to furnish copy to the accused. This is good. Now, secondly, one more thing also they say, this is also really a welcome change. Such copies are to be furnished. That is 207 copies, old 207 copies and now 230. Not only to the accused, it should be supplied to the victim also. This is a good change now. So the victim will know as to what is the charge sheet. Now earlier, victim will be always kept in dark. And if he finds that investigation has not been done properly, to challenge the same before the High Court under 482 or to make an application on 173, he may not have any papers in his hands. He has to make copy application, get copies, etc. etc. Now it is said that from the date of first appearance of the accused, within 14 days, not only to the accused, call the victims, supply all the copies to them also. This, in my view, is something, a progressive provision. So the complainant is also treated on par with the accused. So copies are to be furnished. Regarding this, we can really welcome. But only one thing that disturbs me is the language used. See, and in no case beyond 14 days from the date of production of appearance of the accused or the appearance of the accused, furnished to the accused and the victim if represented by an advocate. Who is this? Why should you force the victim to engage a counsel? He can very well come, he says that I am the victim, give copy to me. It can be given to him. Why do you say that copy will be furnished to the victim if represented by an advocate? I do not understand the logic behind that. He has got right, he is a victim. He has got every right to get copy. Okay, this is one thing. Then one more thing is, on the victim, if the documents are voluminous, what will happen? The victim is represented by an advocate with a copy thereof may furnish the copies through electronic means or direct that he will only be allowed to inspect it either personally or through an advocate in court, provided also that supply of documents in electronic form shall be considered as duly furnished. Correct? So now electronically it can be transferred to the accused as well as to the victims. But again here also Even for furnishing copy through electronic mode, it is said that the complainant or the victim should be represented by an advocate. I do not understand again the logic behind it. That's all is the in respect of the supply of copies. Now let us go to the committal proceedings under section 209. So 207 we have covered, 208 old code we have covered. Now let us go to 209. If the case is exclusively triable by court of session, the magistrate shall commit the case to the court of session. That is what 209 says. Now one proviso has been added to this section. The equivalent provision is 232. You see the proviso. Provided that the proceedings under this section, that is old 209, shall be completed within a period of 90 days from the date of taking cognizance, and such period may be extended by the magistrate for a period not exceeding 180 days for the reason to be recorded in writing. Provided further that any application filed before the magistrate, we will come to the later. Say, let us confine only to the first proviso now. Now it says there is a timeline prescribed for committing a case to the court of session. How much time is given? Within 90 days the case shall be committed to the court of session. Within 90 days. From what date? From the date of the taking cognizance. Within 90 days. Practically, suppose the accused doesn't appear, summons could not be served within 90 days. What will happen? How to commit the case? Therefore, it also provides that the court may extend the period further. But there is another limit which says not exceeding 180 days for the reason to be recorded in writing. So at any rate, the case should be committed within 180 days from the date of taking cognizance, and I do not know whether it will work in the desired manner. There is yet another proviso added. This is also important for you to know. Provided that any application filed before the magistrate by the accused or the victim or any person authorized by such person in a case triable by court of session shall be forwarded to the court of session with the committal of the case. I do not understand once again the logic behind this provision. The case is pending before the magistrate. I make an application for bail, right? It is bailable. For example, section 201 of the IPC, though triable by court of session, it is still bailable. I make an application. Now, as per this provision, the magistrate cannot pass any order on that application. He has to forward that application. He has to wait for the committal of the case. For how many days? 90 days he will wait, and thereafter he will wait for another 180 days. So totally for about 180, 270 days, he cannot pass any order on that bail application because he has to keep it pending, and when case is committed he has to send the application along with that petition. I do not know why this provision. So if the magistrate has got power to dispose of the application, let him do that. Why do you prevent him from passing any order on the application? Therefore, this provision, I don't think that this will withstand the scrutiny of either the High Courts or the Honorable Supreme Court. This is all about section 209. So now case is committed. Then comes the question of framing of charges. Now earlier, under section 240, under section 219, 3 offences of the same kind committed within a year may be charged in a single trial jointly. That is, the accused has committed 3 thefts in 3 different places on 3 different occasions. 3 different FIRs, but he can be tried jointly in respect of all the 3. Now they have changed this provision under section 242. Now they say not exceeding 5. So 3 has now become 5. This is the only change made. I want to rush through for want of time. Now, what are the other changes, important changes made? Now, in respect of then comes the question of discharge. Under section 227 of the code of the CRPC, there is no need for the accused to make any application for discharge at all. He can straight away argue on charges. You know, under section 225 of the code, the public prosecutor will open the case. Under 226, the court will hear the parties on charges. Under 227, the court will discharge if there is no offence made out. It is the obligation of the court. If the court does not discharge the accused, and under 220, the court will frame charges. This was the old code. Now they say that the accused has to make an application for discharge within a period of 60 days from the date of commencement of the case under section 232. That is, after his appearance, within 60 days, he has to make an application for discharge. The accused may prefer an application for discharge within a period of 60 days from the date of commitment of the case under section 232, from the date of commitment. Within 60 days he has to make an application. Let us assume a situation that he does not make an application for discharge. On that score, would you simply blindly frame charges against him? Is it not your obligation to find whether any offence has been made out so as to frame charges? It is your obligation. Why should there be an application? Even if he does not make an application within 60 days, would you not duty bound to examine the records and find whether any charge could be framed? Because there is a prima facie case, or else you have to discharge. Would you refuse to discharge an accused because he has not made an application? Then why this provision? One more thing. This says that within 60 days you have to make an application. I have not made application within 60 days. I come to the court after 160 days with an application. How much delay? 100 days. Section 5 of the Limitation Act is applicable or not? So what is the purpose of introducing this section? Within 60 days you make an application so that it could be disposed of immediately. That is the purpose. But after 60 days you have not made Section 5 of the Limitation Act inapplicable. Section 5 is still applicable. Therefore, after 60 days I can give some reasons. I was sick, I did not read, I did not have legal assistance, etc. I can make application. If that application is, the delay is condoned, then you will enter in this petition. Assuming that my explanation is not accepted and my petition is dismissed. Even then, you cannot frame charges against me because you have to hear me on charges. As per section 227 and now as per section 250. It says, if upon consideration of the record of the case and the documents submitted therewith, and after hearing the submissions of the accused and the prosecution in this behalf, the judge considers that there is not sufficient ground for proceeding against the accused, he shall discharge the accused. So this subsection, they have introduced this subsection 1 saying that you make an application. But subsection 2 does not refer to such an application at all. It does not say, if upon consideration of the record of the case and the document submitted therewith and also the application file and the grounds raised therein. It does not say, it does not even refer to the application. Therefore, if subsection 2 is independently understood, this gives an obligation for the court to discharge the accused if there are no grounds to proceed further and there are no grounds to frame charges. So this is what is done in section 227. Then similarly, after such a petition is disposed of, within a period of 60 days from the date of first hearing on charge, the court shall frame charge. There is a timeline. Suppose the court is not able to frame charge, there are hundreds of accused, then thousands of charges, very big writing. Then if the court, so you say that the court cannot in a mechanical fashion frame the charges, the court has to go through the entire record to frame charges. Would it be practically possible? So therefore we will say that this provision is only directory and not mandatory. Then one more change made is that evidence for prosecution shall be recorded by video, audio, video, electronic means also. See, it says, on the date so fixed, the judge shall proceed to take all such evidence as may be produced in support of the prosecution, provided that evidence of a witness under this subsection may be, not shall be, may be recorded by audio, video, electronic means. The deposition of evidence of any public servant may be taken through audio, video means. Then comes, there are no other changes in respect of trial, procedure, etc. There are no changes. Then comes the judgment. There is one welcome thing made here, though it may not be applicable to the High Court and Supreme Court, where they can keep the cases pending for months together without pronouncing judgment. There is a compulsion on the trial court to give judgments within a period of 30 days. So it's, the section 258 says that as soon as possible, that after hearing is over, after hearing arguments and points of law, if any, the judge shall give a judgment in the case as soon as possible within a period of 30 days from the date of completion of argument, which may be extended to a period of 45 days for reasons to be recorded in writing. So this time is all right, it's good. So within 30 days the court has to give judgment. So in other provisions there are no changes. Then in respect of the warrant procedure for a magistrate also, again they say the accused may prefer an application for discharge within a period of 60 days. Again, same thing is repeated. What is applicable to the Sessions Court is applicable here also. Then audio video recording of the evidence, that is also provided for the magistrate. I do not know how many magistrates will have this video conferencing facility in this country. Now, suppose in a private complaint, some witnesses appear, but they do not turn up for cross-examination. Now what we do now, we keep the case pending, waiting for him to come. Now one provision has been made now to meet that situation, that is section 270 subsection 7, which says that if the attendance of the witness could not be secured for the purpose of cross-examination, eschew his evidence, close the evidence and proceed further. This is good. Otherwise what happens in private complaint, these unscrupulous people, they never come to the court. They simply see that the accused comes for every hearing and he is dragged unnecessarily. To avoid this provision has been made by way of subsection 7 of section 269. I welcome that provision. Then let us go to the one more welcome change. We all know that discharge is possible in a case where it is exclusively triable by court of session can discharge the accused. In warrant cases, the accused can be discharged. There are provisions for discharge under the old code as well as the new code. Under the old code, there is no provision for discharging an accused at all in respect of summons cases. No provision. Adalat Prasad also says the same thing. You cannot discharge the accused once he is summoned. He has to undergo the ordeal of trial and he has to get either acquittal or conviction. This is the only chance in respect of summons cases. There is a welcome change made by adding a proviso to section 274 which is equivalent to section 251 of the old code, which says, provided that if the magistrate considered the accusation as groundless, he shall, after recording reasons in writing, release the accused, and such release shall have the effect of discharge. Though technically it is not a discharge, as it is done in warrant cases and in sessions cases, it will have the effect of discharge. That is the language used. Therefore, we have got now, Adalat Prasad is now given a go-by. So, after the accused appears, when the accusation is, the substance of the accusation is made to him, he has got right of hearing. At that stage, he can say, look, there is no case made out. Please release me. If he is released, so that release will amount to, will have the effect of a discharge. This is really a welcome provision, because Adalat Prasad says that no, once you are summoned, you undergo the ordeal of trial and you got no other option. That is over. Now this is regarding the summons case and all that. Now regarding non-appearance of the accused and all that, I skip. We will go to the regarding delivery of judgment, how it is to be made, old section 354, all these things are simply followed. Let us come to the appeal now. Section 319, adding of accused during trial, no change has been made. Corresponding provision is simply the repetition. Then one more important thing is section 356. I got my own doubt whether this will stand the scrutiny of the Honorable Supreme Court. We say, notwithstanding anything contained in this Sanhita or in any other law for a time being enforced, when a person declared as a proclaimed offender, whether or not charged jointly, has absconded to evade trial and there is no immediate prospect of arresting him, it shall be deemed to operate as a waiver of such right of such person to be present and tried in person, and the court shall, after recording reasons in writing, in the interest of justice, proceed with the trial in the like manner, with the like effect, as if he was present, and this Sanhita unpronounced judgment. I do not know whether this provision will be upheld by this Honorable Court. So if suppose an accused doesn't appear, what are the courses available? You will issue summons, you will issue warrant, you will issue proclamation. Despite that, if he doesn't come, under what was the procedure that was being followed under the old code as per section 317, his case will be split up, it will be kept separately, and after he is secured, as against him, trial will go on. This was the procedure. Now they say, if once proclamation is made, you need not split up the case. It will be deemed that he is present in the court. You proceed with the trial and he pronounced judgment. So in his absence, he will be convicted. What are the problems in this? See, it also say, the provision also say, where, subsection 3, where the proclaimed offender is not represented by any advocate, he is already proclaimed offender. How can he be represented by an advocate? The advocate should get instruction from his client to appear. How can he appear? It says this is highly unreasonable. Where the proclaimed offender is not represented by any advocate, he will never be represented by any advocate. He shall be provided with an advocate for his defense at the expense of the state. All right. One advocate is appointed at the expense of the state. Then it says that advocate will do the case for him without getting any instruction from me as to what had actually happened, what is the defense, what are the defense documents that he has, what are the materials he has, and this lawyer will go and ask, what he will ask? Did you have lunch today? Are you all right? Your health is okay? These are all the cross-examination. What can he, without the authority of the accused, how can he cross-examine and take a defense? He may admit even and say, yes, this occurrence took place, but I acted in exercise of my right of private defense. Whether this lawyer knows about his defense, how can he cross-examine? So this provision, in my considered view, is unconstitutional. Reason being, the fair trial, which is inbuilt in Article 21, is a fundamental right which is inalienable, which cannot be surrendered by the accused. See, for the proposition, we have one judgment of this Honorable Court 1954, 2 SCC, page 278. Paragraph 12 I read. Again, we are not able to subscribe to the view that in a criminal prosecution, it is open to an accused person to waive his constitutional right and get convicted. I do not want to, for paucity of time, I do not want to read the entire paragraph. So therefore it is inalienable. You cannot condemn a person without affording opportunity. Opportunity means he should be physically present. Evidence recorded in his absence is no evidence at all against him. Then not only that, though evidence may be recorded, he is present. He should be afforded an opportunity under section 313 of the old code and corresponding new provision about these incriminating circumstances. That is also done away with. Then after conviction, you have to ask him about the question of sentence. That is also not available. So the right is inalienable. Then how this can be held to be constitutional, I do not understand this. Then this provision, please, I am not able to cover this, which says there are so many other problems with that. The prosecution for offences under this Sanhita, voluntary absence of the accused after a trial has commenced under subsection 1 shall not prevent continuing the trial, including the pronouncement of judgment, even if he is arrested and produced or appears at the conclusion of such a trial. Suppose he was absconding. One day before the judgment he appears. Then he will be convicted the next day. That's all. No going back. We won't allow you to cross-examine, we won't allow you to summon the witness, no nothing doing, we will convict. Then, no appeal shall lie against the judgment under this section unless the proclaimed offender presents himself before the court of appeal, provided that no appeal against the conviction shall lie after the expiry of 3 years from the date of the judgment. No appeal also. Suppose he appears after 3 years, no appeal. A person is somewhere in a foreign country. He doesn't know what is happening here at all. These things happen here, proclamation, etc., goes on here, conviction is given, etc. He returns after 4 years. He comes to know that there is a conviction. Then what is the remedy for you? He cannot file appeal. So he has to go, straight away he has to go to the prison, ask the jailer, please put me in prison because I have been convicted. So that is what is expected of in this. And regarding one more change in respect of old 321, withdrawal of the prosecution by the public prosecutor. Now it cannot be done without issuing notice to the victim. Section 321 equivalent provision now is 360, which says, provided further that no court shall allow such withdrawal without giving an opportunity of being heard to the victim in the case. So withdrawal is not possible without giving opportunity. Then comes the bail provision. In the bail provision, under section 436 capital A of the old code, if the accused has undergone half of the sentence, which is impossible, then he is entitled for bail. Now it says that if he is a first time offender, if he has undergone 1/4 of the sentence, 1/4 or 1/3? 1/4 of the sentence, then he is entitled for 1/4 of the sentence. If he is a first time offender, take for example, if it is a case under 409, 408, where the sentence is up to 10 years. If he is a first time offender, he has undergone 1/4 of the sentence, that is 2.5 years, he is entitled for bail. So many people now who are asking for bail, petitions are pending here. Now we can make application under this provision because we have already seen that the new code, so far bail applications are concerned, we have to make application under the new code. This benefit is available for him. This is yet another welcome trend. And regarding appeal, revision, no change has been made. In the appeal, in fact, there are two problems. One, under the old code, suppose the accused is acquitted by the magistrate, convicted by the sessions court, then there is no right of appeal for him to the High Court. At least one right of appeal is very fundamental to the criminal jurisprudence, but that is not available under the old code. So what we were doing, we were filing only revision. Now this should have been rectified. That has not been done. Similarly, proviso to section 372 does not speak of the punishment, etc. Therefore, these two defects could have been cured, and that has not been done. Apart from that, all the other provisions are one and the same. Regarding arrest, power, etc., etc., I think that I don't find time to cover that you can do. So with this, I think that we can complete our discussion regarding the BNSS and the old code, and we have made, as far as possible, I have compared both, and I have said that as to how to take forward the new provisions. With this, we complete. I am sorry we are not able to adhere to the timeline. There are two more acts. If Sir permits me, we may have it on the same day.
Pardon, sir. I already requested, sir, just now put a note also, 2 more days if possible before 15th August or after 15th August, subject to your convenient. This thing you consider it as per your this thing. We will just welcome. Yes. Many people are interested for food.
Yes, double R.
Give a huge clap. 15th August or now?
Yeah, otherwise, I was also rushing. Despite that, we are not able to complete. I am so sorry, but it needs such kind of in-depth study.